Okay, well, welcome everyone to the Law 2025 online civil litigation Shape the Debate. My name's Andrew McLaughlin and I'm joined today by David Amos. So good
Hello,
afternoon,
everyone.
David.
Hello.
Hello. So this session's due to last 1 hour and it will cover the latest developments in civil litigation featured in Law 2025 online, as well as any pre-submitted questions that have been put to David and I. If you don't get a chance to submit your question ahead of the session, don't forget to sign up to the solicitors group emails to be alerted on upcoming civil litigation Shape the Debate sessions, as well as a regular, free, relevant, and professionally curated updates to support you in practice. This session's sponsored by Watchman Insurance. Watchman is a specialist insurance policy only available to solicitors and provides insurance for unoccupied properties and has been revolutionary in changing the way probate solicitors protect their clients' estates by reducing initial pressure on your funds whilst you are still trying to access the estate and sell the property. Watchman achieves this as solicitors do not have to pay a full upfront premium, covers secured by simply paying a small deposit, and continues with a daily premium charge that is deferred until the property is sold or transferred for up to a year. No finance agreements and no cancellation charges. It's available for homes where clients are in care or with reduced legal capacity. Getting you started and arranging your cover is easy. If you want to learn more about Watchman, then contact their helpful team on, this is the telephone number, 01935 389 812, or their email, which is enquiries at Watchman Services, all one word, so that's watchmanservices.co.uk. If you haven't already, you can still purchase the full law online today, which will give you access to the sessions and topics that we'll be discussing today. So just by way of introduction, I'm Andrew McLaughlin, and I've been doing two courses as part of this webinar presentation and notes. One is on civil procedure, new rules, changes and developments in case law in the last 12 months, and fast track and intermediate track fixed recoverable cost tips and traps, again, over the last 12 months. So I sit as a recorder in the Crown and County Court, amongst other things, and I'll now allow David if he wants to introduce himself, or if you want me to introduce you.
No, I'll say a little bit, Andrew,
Okay, you go ahead.
just to say welcome. I'm an associate professor in the City Law School, and I've done some writing on dispute resolution specifically for SQE students, and I do some work on civil litigation for the Institute of Law in the Isle of Man and Guernsey. So a broader perspective on things, really, I suppose. And for my part, I've done two sessions for Law 2025 online, one on privilege and one on relief from sanctions.
Right. Well, thank you for that very modest introduction, David. I should also say that David's a visiting lecturer for the British Law Centre in Warsaw and Hong Kong universities, which is
No,
a wide.
that's in the past now. Although
Was it in the past? I'm
I did
sorry.
visit Hong Kong recently for something at Hong Kong University, but that wasn't for teaching, unfortunately. It was for something else. So
All right.
yeah.
Okay. Well, I was going to say that's quite a wide geographic spread.
Yes, I know.
So, okay. Well, without further ado, we'll deal with some questions that have already been submitted. As I say, this session's going to last no longer than an hour, and I'll keep my eagle eye on the clock. If we don't get through all the questions, David, then we won't get through all the questions. But hopefully, we can have a discussion about any topics and points that come out of the question. So I think it's probably your turn maybe to ask a question, and then I'll follow on.
Yeah, actually, a question which I'm quite interested to know the full answer to, actually, which is how important is the directions questionnaire in the fast or intermediate track?
Okay. Right, yeah, thanks for that. I mean, really, David, I think it's become very significant now as a result of the introduction of fixed recoverable costs, which, are no longer new. They've been in play for about a year or so. And the reason why the directions questionnaire now becomes so important, it's because it may well be your only one an opportunity to influence a judge as to firstly which track a case is going to a claim is going to be attached to. Is it going to be the fast track or the intermediate track, which obviously brings with it differing cost consequences between the parties, which are quite significant. But not only that, and I'd say as equally important, is the assignment of the band complexity within the track. As you probably know, there are four bandings in each track, each bringing and attracting a different level of costs that are recoverable between the parties. And that can have significant cost consequences, obviously, for the client. In other words, if it gets assigned to a lower band complexity, it will produce less costs between the parties, and obviously the corollary applies. Why the directions questionnaire is so important, therefore, is because I'm going to say it will be relatively rare that a court will ask the parties to attend remotely or in person with a view to determining either track or band complexity. Now, of course, that's possible. Of course, it is. But the difficulty then arises, and it is this: the cost of attending a hearing to argue out either tracking or band complexity brings with it only fixed recoverable costs.
Yeah.
So if you for instance have a if you're based in, I don't know, Canterbury and you've got a case in Newcastle upon Tyne, and the court says attend in person for an assignment to track an allocation to track and an assignment of band complexity, it's going to be utterly disproportionate, cost your client a lot of money to attend that hearing, and there's only a fixed recoverable cost for dealing with it. So I think it's really, really significant that you explain in the directions questionnaire why the appropriate track is, whatever it is, fast track, intermediate track. And if you say it is complex or has a particular value, you've got to explain why you say it is of that value, because your opponent may be saying something different. Clearly, just if we look at it at a general basic level, defendants may well be arguing it should go in the fast track because of X, Y, and Z. For instance, it's not worth more than £25,000. And also the band complexity in the fast track is going to be 2 because, and often the reason is because we don't want to pay more in fixed recoverable costs to the other side than we have to. Whereas a claimant on the other hand may say, no, this claim's worth £40,000, it should go into the intermediate track, and its band complexity should be at 3, which will attract more costs. Now, again, I don't want to spend too much time on it, but it is really, really important that DQ is completed with, if needs be, a separate A4 sheet to supplement what you fill in, to explain to a judge who's going to allocate and assign why your argument should prevail. And that should hopefully avoid a hearing. I'm not saying it will. I think there are going to be tactics adopted, as I've just discussed, where a defendant feels they're going to lose one way or another. and they'll be looking to downsize, as it were, in terms of the track, but also the complexity banding. And the complexity bandings, regrettably, for practitioners, are deliberately widely worded. They give a huge discretion
Yeah,
to,
yeah,
to the judge who's assigning um, to a band complexity, and what makes a band complexity two as opposed to a three in the intermediate track, as I say, remains to be seen. It's where there are more than two issues. Well,
yeah.
there's generally more than two issues
Yeah.
in most cases. But as I say, that's I think really we've dealt with this in front loading cases when the pre-action protocols and the like
Mm,
came
mm.
back in many years ago. Some of our listeners may not even remember front loading as a concept, but it's more preparation and front loading to get yourself in the right band. So, as I say, it's a
Yeah.
good question to start off with because
Yeah, it is, and it's.
yeah.
Oh, sorry, Andrew. Yeah,
No, go
no.
ahead.
The interesting thing for me, as a sort of non-practitioner, and looking at the rules is, as you say, the level of ambiguity about assignment, really, and what arguments you might make about saying it should go into four rather than three or
Yeah,
whatever. So, but it's
yeah.
interesting. There's
I think
nothing.
you're going into band four is probably going to be exceptional.
Yeah,
The
right.
guidance is, intermediate track band four is there may be an argument for saying should go in the multi-track if you're a
Yes.
winning claimant,
Yeah.
but because you might not be able to fit into the criteria of being in the intermediate track. But certainly between two and three, there's a cost differential, and that's where quite a few cases may end up, a volume of cases may end up. And really, if you can need to do your best to try and avoid that, clearly you can discuss it with your opponent, but really, I'm just talking now about where people are intractable about their view, and
Mm.
you've got to put in as much persuasive force as you can in the DQ to try and persuade a judge on the papers that your argument should succeed.
Just one small question on this,
Sure.
if I may, because a
Yeah.
lot of claims will now, of course, go through the damages claims portal, and I'm wondering if that's had any impact on the way people are completing directions questionnaires, or in your experience, that is.
No, I mean, it's actually a big topic now, David, because
Sorry,
no, no,
to
it's
be
all right. No, there's a
saying
big thrust by HMCTS to get digitisation of the
yeah,
civil justice
yeah,
system, and it's creeping along. I mean, there've been recent changes this year to increase the exposure of the digitised side
mm,
of the portals to prevent less paperwork being produced, and also giving litigants in person access to it as well, which is a big step. Because I
mm,
think that maybe the concern is people will start uploading all sorts of.
yeah, yeah,
I'm not saying every litigant in person will do that, but it's a greater risk if people are not legally represented
mm,
um,
mm,
on that. So, but no, I mean the DQs are the same,
mm.
regardless. And that's why I'm suggesting a supplemental A4 to
Right.
get
Okay.
your argument across.
Yeah.
But it's a
Yeah.
good point about
Yeah.
digitisation. I think the Master of the Rolls, Sir Geoffrey Voss, is very keen on digitisation, and many of the other spheres of litigation, family, um, and public family law, by way of example, the Crown Court. It's all digital, diverse platforms, but that's how you're accessing the materials. But it's coming. It's because
Yeah.
that's why it's a
Yeah.
good
It
question.
is.
It's a
Yeah.
big
Yeah.
topic.
Yeah.
It
Yeah.
is coming slowly but surely, and finances plays a big part in it.
Okay. Okay. Excellent. Okay.
Right. Well, I'll ask you a question,
Right. Okay. That's fine.
if I can. And I know you've prepared. materials on privilege. So, what constitutes legal advice for the purposes of legal advice privilege?
Yeah, some of this I think will be effectively revision for people, but I think it's worth re-emphasizing some of these points. But I think the first point to make about the question is it's not just legal advice that's covered by privilege, which is
Right.
a curious thing to say, really. Um, and I think possibly what this addresses is the change in the role of some law firms in
Right.
sense of they're doing more than just giving legal advice. And along the way, if you're dealing with a client, you're going to be dealing with more things than just simple legal advice. But the starting point is that advice must be given in a legal context. So it has that limitation, but then legal advice itself is quite widely defined. So, but that does address a sort of that is reasonable because if you think about it, if you give advice to a client, what are you giving advice to them for? It's to inform the way that they would act. So you give them legal advice, but you wouldn't just say, this is the law. You might say, well, this is how you might implement the law.
Yeah.
And then communications that I make to people, say within a company or whatever, passing on the advice could also be covered by privilege. So there's that aspect to it.
Mm.
But also in your discussions with your client, in the case law, it talks about a continuum of communication. So in forming a view on the advice that you're going to give, forming a relationship with your client, you're going to talk to them about a lot of things other than the law.
Mhm.
And I think and even in very simple ways. So, for example, when discussing this point in the case law, there was discussion about if you're buying a property and you're talking about a loan to buy a property or a business, discussion about the loan isn't necessarily legal advice, but it would be covered by privilege because it's part of the broader context of the legal advice that you're giving to the client. So in that sense, it's quite broad, and it would mean that most communications to and from a client are likely to be seen as uh, covered by legal advice privilege.
Right.
That being said, of course, you've got this dominant purpose point, and so it wouldn't cover things that are purely commercial. Um, but with that sort of rider, legal advice privilege is quite widely drawn. And of course, as well as not being commercial for lawyers, it doesn't cover things like other professional advice. So if you're, for example, advice from a surveyor or something like that might not be covered by legal advice privilege, really.
So, do you have any tips as to how you would, let's say you have a surveyor who gives the lawyer an expert's report or a
Well,
view?
that probably is slightly different,
Yeah.
I would say, because it's the communication with the lawyer, and then I say it's very much about if it's in a legal context,
Mm.
and it's very much the phrase they use is if the advice is given through lawyers' eyes.
Right.
So, um, I mean, the other thing, of course, is that it, what you can do sometimes is if there is something, say, for example, you're in a meeting and there's a series of topics that are discussed, and some of those are topics which are clearly about legal advice, and some of those aren't related to legal advice. What you can do, of course, is redact
Yeah.
stuff that
Yeah.
is legal advice. So you could deal with it that way if you were
Mhm.
concerned about it in that sense.
And
Some of
then,
this is about evidence. Okay, what are you trying to do with the communication with the lawyer? And if it's clear that you're saying this is for legal advice, and you can explain why it's for legal advice or part of the legal relationship with the lawyer, then again, it's likely to be covered by privilege. One of the things the court do
that's
say,
well, that's litigation privilege, isn't it? You know, this
yeah,
dominant purpose test that you've talked about
yeah,
Is
Yeah, it's an interesting one that is because the dominant purpose has now sort of come more into the legal advice since the Jet2.com case. It also is about legal advice. One of the things that you can do
I mean,
is,
if I could just pause you there. I
yeah,
mean, for all listeners, when you say the dominant purpose test of legal advice privilege, what what other purpose is there?
what for? Oh, no, yeah. So no, I get the point you're making. So the dominant purpose is the dominant purpose of what you're saying. Is it for legal advice?
Yeah.
Now it might be, and this is probably more for, I would say, the bigger commercial firms, because of course they would have departments which really are general commercial advice to a client. And what they're trying to do is say to the client, come to us, we're a one-stop shop and we'll give you legal advice, but we'll also give you advice about risks, et cetera,
Mhm.
which aren't strictly legal. Um, what you
Yeah,
can do is set up the terms of your retainer so that it's clear that that's all coming within the umbrella of
yeah. That's
advice.
good,
And
good, good
that's
tip.
probably the way to do it, because
Yeah.
although that's not conclusive and the courts will look at things on a document by document basis,
Mhm.
if you say we're going to act for you in this particular transaction,
Excuse me.
then I think then probably you're saying, well, let's say you're purchasing a series of properties or something like that, then it might well be that you can then sort of include within that general purpose a whole series of things which might not strictly be legal advice, but form part of that continuum of communication, if you like.
Yeah. And again, just another little question, maybe to assist listeners. But what about this thorny topic of disseminating legal advice? In other words, where you're acting for a client and they've got to maybe report or account to someone else.
Well, actually, and I'm trying to remember, I think it's in the Jet 2 case. What they do actually say is it can be passing on and considering or applying the advice within the client.
Right.
Okay. So that is a bit more problematic. And it goes back to what I was saying about sort of evidencing and the context within which the
Yeah.
advice is given. Because if, for example, and I did in the presentation talk about this, if there's an email string which just happens to include the lawyer, nowadays people will
Yeah.
put
Copy in. Yeah.
copy everybody in. That just because the lawyer's been copied in doesn't make it privileged.
No.
It's really about what are you trying to do with this.
Yeah.
And I think if you are in that situation where you're copying a lot of people in, including the lawyer, the thing to think about is if you were just communicating with the lawyer,
Hmm.
would that be come within the ambit of legal advice? If that is the case, then it's privileged. Okay.
Yeah.
And a lawyer might come into you and say, for the sake of argument, that the law has changed on this particular area. And you might say, well, okay, so how in my particular company do I then apply the law? And you could then, the lawyer might give then advice which you then pass on to colleagues as to how you advise uh, how they implement the law. In my opinion, looking at the case law, that would be covered by legal advice privilege.
Right. Yeah. Okay.
So it is a thorny topic, and
Cheers.
it's
Yeah.
not possible to give clear advice because it's quite fact specific as well,
Yeah.
really.
Yeah. I mean, there was a case, wasn't there? Was it, you recall it, West Ham and the Wembley Stadium
Oh,
dispute?
yes.
That's the reason I asked that question. Because was it the trustees of the stadium or whatever, the company were reporting to someone other than as it were, that.
Yeah. Now, the interesting thing about that, because funnily enough, as I was preparing for this, I did look at that case actually, and so just so happens actually, Andrew, and
Yeah,
yeah,
no, it's
I,
fine.
I often wondered about that case, and I had another look at it last night because I was never quite sure about it. And in the judgment, what they say was, or what the argument was, or rather, the way they phrased it was that dominant purpose was discussing a commercial settlement of the dispute when litigation was in contemplation. And I think what looking at what the court was thinking, they focused on the commercial settlement aspect of it rather than it being a preparation for litigation, if you
Yeah,
see what I mean. So I think the courts interpret it as you were having a commercial discussion. You weren't discussing how you would actively deal with the litigation. You were having a commercial discussion.
and therefore became
Yeah,
disclosable.
yeah. That's I think the point,
Yeah,
and I think possibly that goes. It's something to think about if you are engaged in litigation.
yeah,
How you phrase these things. I mean, we can talk more later about litigation privilege, but
yeah,
it's how you phrase those things really,
yeah.
in terms of how you present them to the court. It's quite important, I think.
Okay, so I think you've got a question for me about non-monetary relief, mate. Is it? I don't know. I'm not sure.
Yeah, sure. So the question is, and again, the question I'm interested to know the answer to, so you might see me taking notes,
All right,
actually.
okay. Yeah.
How does the court award costs when there is a non-monetary relief claim in conjunction with a monetary claim?
Okay. Thanks. Well, the answer to that is this, that it may be good news, is the first part of it, because what when we're in the fixed recoverable cost regime,
Hmm,
um, we will look at table 12 and table 14 of part 45. So table 12 deals with the fixed recoverable costs in the fast track,
hmm,
and 14 with the intermediate track. Now, those have assignments of a sum of money dependent on where the claim finishes. You know, it may settle, before trial, and wherever the music stops, so to speak, and the settlement's reached, you can then calculate the amount of costs that's payable, or either to you or payable by you, dependent on who you act for. Often that includes a percentage of damages as well as a fixed amount. So, let's say £6,000 plus 16% of the damages.
yeah,
Okay, so if we recovered um, a monetary sum, we'd get £6,000 plus 16% of that monetary sum. So let's make it easy. Let's call it £20,000. That would be £3,200. So we get six plus 16% of 20 makes 9,200. Where you've got non-monetary relief, you get an additional amount.
right,
Okay, so same case, £20,000 settlement, but also you're successful on the non-monetary relief part. You've sought an injunction to prevent
hmm,
XYZ happening in the future. Under Part 45.45, 1A Roman 2. Uh,
you
so,
just trips off the tongue.
yeah, yeah, 1A Roman 2. The non-monetary relief is assigned a value.
Right, okay,
So, dependent on the complexity band, so if we're in the fast track, the non-monetary relief claim, we will, with a band 3, it's assigned £15,000 value. Okay, so
right, yeah,
instead now of getting 16% of £20,000, we get 16% of £35,000.
right, okay,
So
gotcha.
that's how it works. So it's not just 16% of the 20 that you've won monetarily. You add 15 to that because of the complexity band 3, the non-monetary relief side. So that's how that works. In the intermediate track, which is table 14, the answer, again, with bated breath, 45.50 2B Roman 2. So it's almost like to be or not to be. So it's TB 2B Roman 2 of 45.50. And here the numbers are bigger because it's in the intermediate
Hmm,
track. So a complexity band 3 in the intermediate track, The non-monetary relief alone is £75,000.
Wow.
And it's 50 if it's band two. But you can see if you're getting, say, 20% of 50, which
Yeah.
is 10,
Yeah.
20% of 75 is 15. So that's why that's keep going back to getting the complexity pan right, because you're just getting an extra £5,000 purely for the
Mm.
non-monetary relief side of it. Now, obviously, if the claim settle for £50,000 in damages and a non-monetary relief, let's say an injunction, it's a similar calculation. But what I wanted to do was like tease out and pull out the non-monetary relief valuations. And again, just for if people are wondering, does it matter whether you go over £100,000? No, it doesn't.
Mm.
It would still be an intermediate track case. So if you recover £75,000 in damages and it's a complexity band three case with
Mm.
non-monetary relief, that also has a £75,000 value. So you get whatever percent, let's call it 20, will be 20% of 150,000, even though it's in the intermediate track, and the intermediate track's still up to 100. It's just a deemed value.
Well,
Okay.
I think, I mean, two things that strike me about that actually.
Yeah.
It's first of all, it's sensible because you're dealing with monetary and non-monetary relief, so there is an additional element of complexity in the case.
Sure.
The second thing is actually it's pretty generous, really, to the
Yeah.
latter figures anyway, the intermediate track figures seem
Sure.
pretty generous to me.
And tactically, which is in the webinar, defendants perhaps predominantly have got to be wary, I think,
Yeah,
of
yeah,
claimants putting on as an add-on a
yeah,
non-monetary relief claim with a view to
yeah,
upping the deemed value of the claim. But the
yeah,
so defendants need to be aware of that. Now, housing disrepair, which isn't part of the fixed recoverable cost regime at present, generally pleads an injunction for
yeah,
a
of course.
landlord to perform repairs.
Yeah, yeah,
So at some
yeah,
stage, because housing claims, including housing disrepair, will come in to the fixed recoverable costs regime sooner or later. But it's often, specific performance for repairs.
yeah. I,
Uh,
I was going to, I did wonder about that actually, because one of my best friends does a lot of housing disrepair claims, and I'm thinking, at what point does the party stop, in a sense, and it becomes under the? Have you any inkling of when that might be, Andrew?
Maybe in the next 12 months or so. The answer is I don't know.
Yeah,
But
yeah,
people will be working towards getting non-FRC work into the fixed recoverable cost regime
yeah, yeah,
because it seems including clinical negligence that may
yeah.
expand as
Mm,
well. But at present it's in, but only where liability and causation have been admitted. So
mm.
that it may be the next little creep would be to include more of them, but we just have to wait. But
It,
again, it's just getting the rules right and to make sure that the recovery is deemed. I'm not commenting one way or the other.
mm,
Um,
mm.
deemed to be fair. I mean, most practitioners would, I suspect, say, well, these are crazy low figures. I can,
Yeah.
well understand that. I mean, if you compare with what you could have got, it sounds a bit like uh, some sort of game show.
Yeah.
Look what you could have won.
Draw.
Is demonstrably lower, and of course the impact is on the client ultimately, unless you're going to bring your fees down to
Yeah,
reflect this, and which is another conversation.
because
Which
it
I
does
try
have an impact on the way that cases are litigated inevitably.
absolutely, yeah, yeah.
Yeah, and
If you're clever, if you're a clever
yeah,
defendant, you settle just
yeah,
before you reach in another phase of an
of course.
intermediate track
Yeah,
case
yeah,
to
yeah,
to stop the leap into more costs
yeah, yeah,
and the
exactly.
like. And people have got to work out on a fact sensitive, case sensitive basis how best to do that for their client. Um,
Mm.
but as I say, that's how it's dealt with. Um, I mean, is there anything more coming out of that, David? Or
Not from my point of view.
okay,
Not from my point of view. And I'm conscious as well. We do have other questions.
yeah, of course, yeah. We've got been submitted a
Not
few.
necessarily mine, but yours.
Well, yours as well. I mean, so I'll move on to the next question. To what extent can privilege be relied on in relation to preparations for possible litigation?
Yeah, and it's an interesting one because, and it's about in the presentation I started with, which people will be familiar with, the definition of litigation privilege. So it's not actually just privilege that's ongoing now; it's in contemplation of privilege, and there are various different aspects to consider. I mean, the obvious one is litigation realistically in prospect. Um, and one of the reasons I sort of included this was because there was, or talked about this in, was there was a recent case, Kyla Shipping and Freight Trading, which didn't set that bar particularly high. It quoted, I think, the US and Philip Morris case, and it said it doesn't have to be a 50% or more chance of litigation. So the bar isn't particularly high. That being said, you have to show that there were circumstances which meant that litigation was a real likelihood. Um, and we can come back to that later because there are other things I want to discuss. But again, it's about evidence as to what it is, what could you show that there were, or how could you show that there were circumstances which meant that you were anticipating litigation? Um, I don't want to go through the facts of that particular case in too much depth, but one of the things the court did say in giving their judgment about a report that had been prepared was this effectively said to the solicitor, well, you didn't make much of an effort to explain why it's privileged, did you really? So I think, and it's that evidence point is something I'll come back to actually. Because the other thing, and which we talked about before, is the if you're going to say that it's for contemplated litigation, quite often evidence is produced and it might be for more than one purpose. So we go back to the dominant purpose point, really.
Mm.
What is the dominant purpose of the investigations or the documentation that you're producing as a result of those investigations? And that is probably where the evidence point would come in, because what you're wanting to show is we've done this because we thought there was going to be a case of whatever description coming up. And so think about that when you're doing pre-litigation investigations, so that if privilege is challenged, you can say, well, this is why we did it in the first place. Um, the other thing that came out of the case law, which is quite an interesting argument, I think, and it may be something that I discuss later, and it's an interesting case about whether an identity is privileged, but this Lorelei financing case. And one of the arguments that the counsel for Lorelei financing in that case put forward was that the purpose of don't sorry, I'll do this in a different way. The purpose of litigation is there is a zone of privacy around preparation for litigation, and that's the purpose of litigation privilege, is that there should be a zone of privacy. Um, but the court said, well, actually, there's no basis for that in law.
Mm.
So there has to be criteria, and you have to satisfy those criteria if you're going to be able to claim privilege for steps that you took prior to litigation. And that, I say, is where the evidence points comes in. And there is actually some quite helpful suggestions. The Law Society produce every so often some guidance on how to deal with privilege and what steps you might take. And I've pointed people to some guidance on that. But again, it goes back to what I was saying earlier about being consciously saying that we're doing this because there may be litigation and we're carrying out these investigations because there may be litigation. Now, of course, what happens is within a company, they might do the investigations and then get the lawyer involved.
Yeah.
But that's something to perhaps discuss with your client.
Yeah.
It
I mean,
also raised,
one of the points that has
yeah,
been
sorry.
raised in a question, I mean, just sort of um, morphing into that is what about witnesses or parties being privileged, the names of them? What's the...
Well, the standard position for witnesses. Well, actually, no. I'll take it back a step
Right.
because that is the Lorelei financing case, and it was an interesting case because it wasn't something that you would encounter every day because Lorelei financing were one of these special purpose vehicles,
Mm.
and essentially nobody worked for the company, and any staff that they used were hired in.
Right.
So the defendants were saying, well, where are you getting instructions from? Who's actually giving you your instructions? Which are not an unreasonable point, really, to be honest. And so they put in a Part 18 request, and that was defended. That request was denied on the basis that that information was privileged. Now, in essence, the court said it wasn't.
Yeah.
But it said two things. The idea of privilege is to allow a party to have proper discussion with their solicitor, and therefore anything that is said between a party and their solicitor about the strategy for a case, etc., should be privileged.
Mhm.
But what the court said was revealing the identity wouldn't necessarily reveal the content of the communications between a party and their solicitor, or inhibit discussion with the solicitor or reveal their litigation strategy.
Right.
So, on that basis, they said the identity of a party isn't privileged.
Mm.
And they made, I think, quite a sensible point, which is in most cases, what you will do is produce a witness statement from that person,
Yeah.
and therefore you will find out who they are.
Yeah.
That being said, the court did say that in certain cases, if it was going to inhibit discussion or if it was going to reveal the litigation strategy, then the identity could be privileged, but they didn't think that was particularly likely.
Right.
That was in contrast to
Yeah.
witnesses. Now, witnesses clearly, if you reveal the name of your witnesses, that's likely to reveal something about the case that you're
Mhm.
preparing.
Sure.
So that the witnesses, the third parties, are privileged. It's just the identity of the party concerned isn't.
Yeah. So really, because this is an interesting point, because a witness statement prepared by a solicitor is privileged,
Mm, mm.
the client has the privilege of it. What happens when you're filling in, for instance, directions questionnaire? Are you actually obliged to say, say how many witnesses, name of witnesses you intend to call when you may not want to call witness D.
Yeah, no, that is an interesting one, and it wasn't that sort of practical point wasn't actually dealt with in
No.
the case. And I must confess, actually, when I first looked at this case, I thought it wasn't a particularly wide applicability, but it has been applied in other cases. So
Yeah.
I think probably the reality is, and it goes back to something you said earlier about front loading. The
Mhm.
reality is, in a lot of cases, if you followed the protocol, a fair bit of this information will have come out,
Yes.
I've thought already. So, I mean, but to address your point, if you're concerned about privilege, I guess you could say we will be calling witness A, B, C, and D, and then have the argument about whether or not that information was privileged if the other side object. I mean,
Yeah.
it's a curious sort of I mean, I'm trying to work out how that would work in practice, but
Well,
um,
suppose you maybe, I mean, just interrupting, maybe just
yeah,
argue, well, it's an adversarial process.
yeah,
We're at the early stages of the litigation. We may be relying on four witnesses, which may assist the court in terms of
mm,
trial time or whatever
mm,
going forward, but we've not actually decided which witness evidence we're going to disclose at this stage. And that's why we've not named the witnesses, because we're entitled to we're entitled to keep the identity of the witnesses, not the parties, but
Yeah,
not the managing director, but
yeah.
maybe a third party witness who the other side haven't clocked as being relevant and pertinent, and you want to serve that on them and say, "Wow, look at the strength of our case."
Yeah, I mean, it's an interesting one because, I mean, basically, litigation is cards up front, cards on the table, isn't it, really?
Sure.
But the directions questionnaire, really, going back to something you said earlier, is well, it's interesting because I would interpret it as largely being procedural rather than substantive. But
Yeah,
if you're going to have the discussion that you said earlier about which track and which band it should go into, complexity band,
yeah.
then there is going to be an element of substantive in the director's
Okay.
questionnaire. So I suppose it's a tactical discussion about how much of your hand you reveal and at what point. I mean, you are
Yeah,
going to have to
because
reveal it at some point or other,
yeah, I
really.
mean, but that'd be when you serve the Part 32
Yeah,
witness
yeah,
statements,
yeah,
won't it? When it is, it's cards on the table, face
yeah,
up. That's
yeah,
the moment when
yeah.
the cards are produced. I mean, I've filled endless numbers of them in, and my policy is generally not to name the witness.
Mm,
Just
mm,
say we're
mm.
calling three witnesses without
Yeah,
naming them. But if somebody said, "Okay, that's interesting," which witnesses? Which witnesses he intending calling? Because obviously, as soon as you reveal the name, they're gonna. The risk is you do a client a disservice because they can no property in a witness.
yeah, of course. Yeah,
Let's go
yeah,
and
yeah,
interview David
yeah,
Amos, see what
yeah,
he's going to
yeah,
say about
yeah.
it. And I mean, I've had cases where you've had witness statements, and in fact, in one case a witness statement or for both sides of three witnesses.
Well, the same witnesses.
There's three witnesses who prepared witness statements for the claimant.
Did they say the
And
same thing?
well, surprisingly, no, they didn't. Because I just form the view whoever interviews them,
Yeah, yeah,
um, they tend to sort of take a steer on be it claimant or defendant who's interviewed them. But it's a good way of diminishing someone's credibility, just sort of
yeah.
say,
It is. Yeah, yeah,
if they say
yeah,
something slightly different, it can be used,
yeah.
in terms of the reliability as a witness. But it's as I say, it's just an interesting
I take your point
conversation.
about the not naming the witnesses in the directions questionnaire. I think that probably is the best way to do it, really.
Yeah.
So,
Yeah, and somebody can take it up,
yeah,
can't they?
yeah,
Someone wants to
take
pick
it.
it up and sort of say,
Yeah,
yeah,
yeah.
where are they?
Okay,
Okay.
shall we?
Yeah, we've got 10 minutes. That's all.
Okay. Well, how? The next question on my list, and I'm
Yeah,
going to be
sure.
quite flexible here, but the next question on
Mm.
my list is, how does a court deal with a Part 36 offer when it does not involve an offer of monetary compensation? Do you want to deal with that one, or do you want to
Yeah,
move?
sure.
Yeah,
I'll
yeah,
deal with it
yeah,
briefly. I mean, and
yeah.
the answer is in a case called Rahman versus Hassan from August 24. And this
Right,
was a dispute about deathbed um, gifts. Somebody was
right.
dying, and there was a dispute as to how much they'd given away. Um, and the issue was it furniture and personal effects, or was it two flats?
Oh
And so there was
God.
a Part 36 offer. So there was obviously value,
Right.
but
Yeah.
the Part
Yeah.
36 offer was premised on the basis of chattels
Mm,
or real
mm,
property.
mm.
And it transpired the claimant did better than it was more advantageous. Um, and at least as advantageous, which is contained within Part 36. Those are the tests under 36.17 of the rules. The court said they can be construed in their ordinary sense. They don't have to have a monetary value attaching to
Right.
them. So you
Yeah.
can make a Part 36
Yeah.
offer saying, I want to flatten, the household effects is my Part 36 offer. And when you get to
Right.
court, you win two flats.
Okay.
And the court says, well, obviously two flats are worth more than one flat and personal effects. So you've done better than your own Part 36 offer. So you get indemnity costs from the end of the
It's interesting.
relevant period and interest on the indemnity costs. So, Part 36 is flexible, and it's meant to be um, a tool to compromise cases. And the courts obviously are I'm not even saying bend over backwards, but will ensure, as with it legitimately, that any form of Part 36 offer is a valid Part 36 offer. So it doesn't have to have a non-monetary value, and you get, the indemnity costs as a consequence.
But that makes total sense to me, actually. As
Yeah.
you say, the purpose of it is to settle claims, so that makes perfect sense, really.
Yeah.
Yeah, yeah.
Okay, so I'll move on
Well,
to
Andrew, can we? I
yeah,
wonder actually. There are some questions about relief from
the
sanctions.
sanctions. Sure.
I've not dealt with that, so um,
Yeah.
I perhaps I've got a list of quite the first one. Perhaps the
Okay. When does Denton and the
yeah,
rules on
yeah.
relief from sanctions apply?
The reason I say
Yeah,
this
it's a good
because it's so
question actually. I don't know who sent it in, but that was a good one.
they're so fundamental, and there's been quite a lot of litigation about it. And
Yeah.
lawyers, being lawyers, they've been quite creative, I think, in their arguments
Mm.
about it. And I could go through this a little bit in the presentation. So I just really want to draw
Yes.
together, because we haven't got long,
Mhm.
some of the key points.
Yes. Please do.
Yeah. So the first, I'll take the cases slightly out of the order in which I dealt with them
Uh-huh.
in the presentation.
Sure.
And there was a case, Yes Electrical and Warren. I was reminded of this actually. I was in Guernsey recently. I saw a Yes Electrical, which is the first time I've ever seen one. So I
You know
thought,
what?
oh,
I saw one this morning.
did you? All
Honestly,
right.
yes, it's got various logos.
Yes, three
Yes,
S's. Yes,
security.
yes, I know. Yeah, I know. So,
Wow, that
but
is.
I know, yes, I didn't think no, I never knew they existed until that point. But anyway, so the first thing is, and it comes from the sort of the Yes Electrical case.
Yes.
And the first point is, I'll start with that case because it's set out quite neatly, I think, the steps, which might seem obvious, but perhaps not as obvious because the courts have had to stay them. Um, the first is, well, has there been a rule, practice, direction, or order that's been breached? So
Yeah.
that's the first requirement. Secondly, is there a sanction
Mm.
attached to breach? But if there isn't, you might still have to come within the relief from sanctions regime anyway. And that's when I'm going to flip on to the next case, which is the FXF and English Karate Federation case, which you probably remember it dealt specifically with if you're applying to set aside a default judgment, does that also have to be a relief from sanctions application? And that was the specific point that was dealt with in that case, and they said yes.
Mhm.
Um, but what they said in FXS, S, FXF
Mhm.
was that there are essentially three situations. Firstly, the one we just sketched out is, does the rule or order expressly provide a sanction? And the example they used, the failure to file witness statements on time.
Yeah.
And sanction there is you can't rely on the witness. So that clearly comes within that sort of situation. Um, the third one I'll skip on to, which is the one that they dealt with in FXF, sorry, I can't say that,
Yeah.
is is there a further step that needs to be taken as a result of the non-compliance? And that was the reason why, in that particular case, they said if you're applying to set aside default judgment, or and the other example they used was where a claim was struck out for non-attendance, you would have to apply to the court, but that would be a relief from sanction, essentially be dealt with as a relief from sanctions application, or you would make the application alongside it's part 13, isn't it, that deals,
Mhm.
you would make the relief from sanctions application alongside that.
Yeah.
But the second of the three was what they call implied sanctions.
Yes.
And that's where the rule doesn't expressly state a sanction, but permission would be needed to proceed.
Mhm.
Now, that actually, we haven't got long, so I'll just say this quickly. That actually hasn't been used very extensively. I think that's the area where litigators are trying to expand whether relief from sanctions should apply, but it's only really been used to failure to file a notice of appeal or respondent's failure to file a notice of appeal. And the other case law says that the hurdle for finding an implied sanction and therefore the need to go down the relief from sanctions route is quite high. So then the court aren't going to imply
Yeah.
sanctions or the need to go down the relief from sanctions route particularly easily in that situation.
Yeah. So, yeah, I mean, that's interesting. And I suppose, really, I mean, trying to tie it all together, as I understand it, even if you can, as it were, side, uh, well, negotiate around a relief from sanctions application, a court still ultimately has a power under the overriding objective to strike a case out, because in fact, 3.9 is it's not dissimilar wording to the overriding objective. I know there's all
No,
the
no,
circumstances of the
no.
case, but
Yeah.
conduct litigation effectively, proportionate cost and the like, comply with rules, practice directions and orders is in 3.9, but similarly in 1.1.
Yeah, and I think that very absolutely, and actually, what the case law says two things. Firstly, if you aren't coming under the relief from sanctions regime, the court can still look at the factors under the relief from sanctions regime because they are so similar under the to the requirements of the overriding objective.
Yeah,
The second thing they said is one of the main differences between the two types of application is in a relief from sanctions application, you're not arguing what the sanctions should be, you're just arguing whether the sanctions should be upheld.
yes,
Whereas in any other application, you can argue what the sanctions should be. That could include strikeout, of course. And the question is whether it's reasonable, proportionate, etc., to apply that sanction.
yeah,
So it wouldn't stop, even if it was a relief from if it wasn't a relief from sanctions application, it wouldn't stop you getting a case or getting a case struck out,
yeah.
basically. Yeah. Sorry, we'd have to rush that a bit because we're
Um,
pushing up against the hour. So
I mean, again, just throwing this out just
yeah,
to try and develop it as a last point, and we'll finish. Is Well, let's say the case is struck out.
yeah.
Is there any sort of recent case? I mean, you may not know. Is there any recent case law where people have then recommenced a claim that has been struck out? Over the courts take that with regard to potential abuse of process, or
I on off the top of my head, Andrew, I couldn't say unless you're aware of any.
no? No, I think
I,
my
I
understanding is it's going to be difficult to argue an abuse of process where a claim's been procedurally struck out.
yeah,
um,
yeah,
and not being litigated in inverted commas, where evidence hasn't been tested. But
yeah. Because
I suspect it's fact sensitive to some, to some degree. Um,
I
I mean,
suppose it's
yeah, sorry.
yeah, yeah. It's an interesting one because I'm trying to think it through because I mean, if you were still within the limitation period, that's the
Yeah,
step I would take is to
absolutely. Yeah, yeah,
start it again.
yeah,
But I suppose if there's any element of you relitigating arguments that you've already raised, and okay, it was struck out on a procedural basis,
yeah.
then you could face an abusive process, and possibly you could argue that. Oh, but I'm afraid I'm not aware of any
No,
recent case that was dealt specifically with that point, actually.
I'm aware of one years and years ago that basically said it on the fact was unlikely to be an abusive process for the
Mm,
reasons I've
mm,
outlined, namely
mm, mm.
nobody's had the day in court, and obviously the costs thrown away by the
Yeah,
litigation that's been struck out is one point. But the defendants, I suppose, if it were that the defendants could argue, well, it couldn't argue, well, we didn't get our costs back. For instance, from an unsuccessful claim, it could be an abuse there where the claimant goes again not having met the cost penalties of the cost sanctions of the
And
matter that's been struck out.
I can see actually I can see that being an argument
It is,
because
yeah. That's
yeah,
about
I
it,
can see
really.
that being an argument, and actually because in one of the other cases that we're not going to get to talk about, which was about it's Smith and Kierkegaard, what that part of that related about non-payment of costs, and one of the things that the court did say in that case is, non-compliance with orders is something that we're going to sort of not look on favourably.
Mm.
Okay. So if a party hadn't paid their cost, I think there are a good argument, even if it's not struck out, at least for the claim to be stayed until the costs of the earlier action are
Yeah,
paid.
yeah. It's true.
So so I think there is an argument there. On the substantive question, I'm less sure, but
Yeah,
I
no,
definitely would be on the cost point.
yeah. And I suppose that may well bring many cases to a conclusion, where
Yeah,
the unsuccessful applicant for relief from sanctions hasn't paid the costs of the initial substantive action,
yeah.
so I'll have a go again.
Yeah,
But
yeah. And again, you run. I mean, it's probably more as well that if you continue to litigate things in that way, is whether you considered as a vexatious litigant, or although the bar for that's pretty high, really, to be
yeah,
honest.
yeah,
So
sure.
yeah,
Yes, yeah. Okay, well, I think that brings us to an end. As ever, David, that's all we've got time for. And as I say, as ever, thanks for, you and I hope, contributing and having a good natter about
yeah,
these particular topics. I think hopefully we've sort of expanded people's learning or our experience of it beyond, what's just in the notes and in the
yeah.
webinars that we
I,
present.
I've certainly learnt a lot from you, and I shall be looking up those specific elements of the CPR after the session.
Well, and I've learned material from yourself as well, so that's useful for us both. So I think we'll bring it to a conclusion. There is still time to book and watch the full pre-recorded content that is available from this law online. It's accessible for 90 days from the day of purchase, and allows you time and a place that's convenient to you to get the benefit of it, which I think in these busy days is a lovely feature to have. And if you want it, it's on www.thesolicitorsgroup, all one word.co.uk. There's a feedback form to complete, and by completing it, you'll receive your CPD certificate. So thank you very much indeed, David, and thank
Thank you,
you one
Andrew.
and all, and have a great day. And that concludes our Law Online Shaping the Debate. Thank you.
Right, thank you very much.
Thanks.